Hello everyone, welcome to the manager training. This presentation is presented by Baran, Alexandra, Hongru, Lindsay, and Kyungduk. This manager training is different than other manager training because we are going to focus on union managers. When someone is hired as union manager, mostly they don't have a confidence because a lot of people say managing union worker is really difficult and complicated. However, as long as the manager know what is going on and what they have to do, it is not that difficult and complicated. Sometimes it might be easier because there is a procedure the manager can follow depends on the situation. We hope this manager training presentation help you to be a great manager in union environment. Then let's start. This is the agenda. First, we are going to talk about introduction. I'm going to show you guys a video that explained about union. Second, union and management right. Third, hiring, promotion, and seniority. Fourth, scheduling and rate of pay. Fifth, discipline and discharge. Lastly, conclusion. Union. What is union? How can you guys define union? Union is an organization of workers who have come together to achieve many common goals, such as protecting the integrity of their trade, improving safety standards, and attaining better wages, benefits such as vacation, healthcare, and retirement, and working conditions through the increased bargaining power willed by creation of a monopoly of the workers. If you already took HOA 508 class, you might already know what the union is and how it works. However, please watch the video. It is only a minute's video and explain well about the union. You have to know the definition and their goal well in order to manage union workers.
We're going to talk about the rights of the union and the management. So first is the different types of union security. Union shop is part of the labor contract that says all employees have to join the union within 30 days after being hired. And what this means is that they are responsible for paying union dues, initiation fees, and they must remain members in good standing. You can get kicked out of a union for not paying those dues or if you join a picket. All bargaining unit employees must join and remain members of the union. But Nevada is a right-to-work state, so how can this be legal in a contract? The key words to look for are, to the extent this is a violation of the state law, it is not enforceable. This means the contract is for 5 years, and Nevada changes their laws before that, then they are still following this agreement. So basically, the contract stays the same until it ends. An agency shop is an in-between option. You do not have to join the union or pay fees, but members do have to pay the union dues. They are only paying dues that go towards the contract. Then we have the checkoff agreement. This is when the employee wages are deducted for union dues and fees. It's a payroll deduction. This option costs more to the company, but it's very valuable to the union. Union access. So the union agents are not allowed to go on employers' property except for the following reasons. They can meet with bargaining unit employees. They can be there for benefits registration. So representatives of employee benefits plans may visit for the purpose of educating the employees about and enrolling them in plans, programs, or financial institutions. They can also be on property for grievance procedure. Within those exceptions there are limitations of how they can go on property. They do need to set it up with the employer ahead of time, check in upon arrival, etc. There are also employer stewards. These are direct representatives of the union. Anything union-related must be done unpaid and not interfering with their regular work schedule. So they have to do this on their own time. Also, the unions have the right to some information about the employees. Monthly reports are sent from the employer to the union. The reports are about new hires, promotions, terminations, leave of absence, and employee contact information. Every contract puts some sort of a no strike and no lockout clause in place. There are some exceptions to this rule. First is members who want to cross picket. If they do this, they have to quit the union if they want to go back to work. The employer can refuse to take these people back if they are on strike, but this typically doesn't happen often. Second is if a company refuses to comply with an arbitration award. It is not illegal for a company to refuse, so the union typically goes on strike to enforce this. Lastly is a sympathy strike, which is when one union goes on strike to help another union that is currently on strike. It puts a lot more pressure on the employer and the company. Rights of management. We have the zipper clause, which is what you see is everything. There is nothing else that we have agreed to that is missing from this contract. This helps protect management and preserve their rights. They do not want the union to be involved in things like scheduling, making business decisions, promotions, transfers, training, uniforms, etc. Now, if a company makes a new rule or something that affects the union, then management has to inform the union of these changes. This ensures managers don't take their rights too far. Unions are then able to challenge these new rules. So, for example, a company wants to start replacing bartenders with robot bartenders. The company must inform the union ahead of time in writing with a proposed date of when this new equipment will be introduced. The union and the employer will then meet to discuss the possible outcomes and effects of this new equipment, including alternative bargaining unit employment for the current employees being affected.
I'm going to share some information and tips of hiring process, promotion, and seniority. First, when employers hire someone, you may notify the union. The union can assist employers better to help find the applicants and candidates who meet the job requirements. Applicants should get equal treatment. There is no discriminatory basis. Employers cannot accept or reject applicants based on their race, color, gender, religion, age, sexual orientation, or other any national origin, and cannot based on if person enjoys the union or interferes with any rules, laws, regulations, constitutional provisions of union. And the requirements of applicants should be based on their qualification, ability, experience, or suitability of the position. For example, if you hire or and select someone from applicants, the one person is white male and the other person is Asian female. You should consider if they reach enough abilities to they can do well for this position rather than their races or countries. And it also the same thing for promotion. There's no discriminatory basis for promotion. And there's one thing you should remember. Employers cannot hire employee and send their employee to the position without a referral slip from union's dispatch office, except in emergencies. And employees should notify the applicants when dispatches for available position, and the union should register the proof for applicants. And also, employers should select employees as probationary who have 40 shifts of work. After they finishing 50 shifts, the employers are able to decide whether to terminate or extend the employee's probation period with union discussion and agreement. Seniority based on how long employees have been working in this position. When your organization need to be forced to lay off employees under some certain situation, such as you need to consider to decrease labor costs or meet some financial crisis. The probationary employee may be the first one to should lay off and recall to their regular job classification due to their seniorities. And if employees who have been working for less than 6 months transfer to the other position, they have recall rights to their former immediate position for 6 months. Or employee who have been working for more than 6 months transfer to other position. We also have recall rights to their former limited position for 12 months. And if employees who have enough seniority, they may not be laid off. For example, some professional and gourmet room chefs and cookers can replace other chefs in the kitchen if they have enough seniorities and qualification to do other kitchen jobs.
So I'm going to talk about the schedule and your pay. So regularly, the employee should get paid weekly, but during my job experience, I always get paid for every 2 weeks. It's okay. It's okay. It's allowed to let the company pay you like a half month or 2 weeks. And the next is your tips. The all tips from the customer should be all belong to the employees. And I know in some case, some restaurant may put the tips together for a whole day and end of shift and separate to everyone. But in this case, you should make a deal before you start work, which means you get everyone agree with it. And even when people disagree, you cannot ask them to do that. And next, for the dismissed people and the resigned employee, when you want to dismiss the people, your employee, and it's pretty hard. You got to pay everything whatever they should get in 24 hours because you fired them. And for the people who is resigned, here is the two situations for the time limited. The first one is the regular day you pay them like maybe weekly or 2 weeks. And the second way is 7 days after. Because I already see, some company pay like 2 weeks, the people cannot wait like 2 weeks. So the best situation is 7 days. And also, many people get to even more different kind of job. So whatever the job you get, and even the whole shift you get makes two different position, maybe more position, but you can get paid from the highest position. So which means you get when maybe you get something get paid like $15 per hour, and the other one is 19, and work whole day. You did both job, both position, but you can get the highest one, which means you can get highest one is $19. And also the kind of special in Las Vegas casino, and for the new employee, the bartender, and if you work less than 2,000 hours, and in your first 36 months, and first 90 hours, maybe you can only get like 80% for your normal payment. But after that, you will get the regular ones. But for all of those, we just talk about the regular situation. But sometimes people make some different deal. And the next will be your shift and the overtime. A lot of people care about that. So first one is a 4 shift. The 5 days per week and 8 hours per day. And the other one is 4 days per week and 10 hours per day. So all of those is like 40 hours per week. And I know maybe some special offer, like you gotta work like 7 days and you have a 3 days day off. Because the job is different, and maybe somewhere have different deal, but usually it's 40 hours per week. It's a regular time. And also there is a short shift, which is 6 hours or less. And the overtime, it's always happened for the overtime. So overtime means depends on your full-time shift job. So if you get 8 hours per day, so after 8 hours, it's still overtime. If you get 10 hours per day, after 10 hours, it's still overtime. So whatever for a whole week, if you have full-time shift and over 40 hours a week, and the overtime will be after 40 hours. So how do we get the pay for the overtime? First of all, you get the regular payment rent and multiply by your overtime and multiply by 1.5%. So just like see example, the employee who get the payment for $20 per week, per hour. And for this week, she works like 50 hours. So, usually the full-time hour is 40. So she had 10 hours overtime. 10 hours multiplied by 1.5, and the regular payment is $20. So finally, she get $300 for overtime pay. And also here is more different situation, like you get to continue how many days, like you get to continue working like 6 days, just like I said. It's too many jobs and too many deals. So it depends on what the deal you make, okay? And finally, after all of this, and you're gonna continue and your loyalty for the company, like years, continue doing your job years, which means you didn't stop and resign your work. So you get a pay vacation. So for the employee who are working continue like 1 year, you get a 1 week pay vacation, 2 years for 2 weeks, 6 years for 3 weeks, 12 years for 4 weeks. I know sometimes people, it's pretty hard to continue working for one place for many years. But yeah, since you get a long work time and you get a long time for the pay vacation. Yeah, that's it. That's all the part for the scheduling and your pay.
Now we are going to talk about discipline and discharge. In any organizations where a union is established, no regular employee or steady extra shall be discharged except for just cause. Here, regular means full-time or part-time, and steady extra means regularly on the payroll, so-called on-call. When you discipline or discharge an employee, you need to have just cause. Just cause is a standard that management must adhere to when disciplining or discharging an employee. It means that the employee must have a reason to act in disciplining an employee, and the reason must be just and fair. There are 7 steps of just cause. The first step is the notice. You need to ask yourself, did you warn the employee of what would happen after his or her conduct? For instance, if an employee keeps coming to work late and you told him that he would get suspended if he's late again, that is an adequate warning. The second step is the reasonable rule or work order. Ask yourself, was the company rule reasonably related to expeditious and safe work environment? For example, if construction workers are required to wear a yellow helmet at the workplace, but John wears a pink helmet, he would not get fired because wearing a helmet is to protect workers, but the color of the helmet has nothing to do with safety or efficiency. Next, you need to check if sufficient investigation has been done. Remember, you must investigate the incident before making decisions regarding disciplines. Also, the investigation must be fair. Make sure that the investigation is done impartially and unbiased. For example, employers must interview everyone present at the incident, not just management level workers. Next, you need to have proof. The question you ask here is, did the investigation produce substantial evidence or proof or guilt? It must be legit evidence, not guesses. Next step is equal treatment. Were the rules, orders, and penalties applied fairly and with no discrimination? For example, when Jay comes to work late on Monday, he gets disciplined by the supervisor. But next day, Paul comes to work late but does not get disciplined because the supervisor came to work late as well. This is not going to work. The last step is appropriate discipline. Was the penalty reasonably related to the significance of the offense and the past record? For instance, 2 employees get involved in a fight. One has worked for the company for 10 years with a clean record. The other has worked for a year and caused many troubles. The management would give the older worker less punishment than the other worker based on the worker's seniority and records.
Now it is time for the conclusion. Do you guys feel comfortable managing union workers now? Even though a lot of people said it is difficult and complicated, now you guys can tell them it is not, because you all know the rules, contract, and have ideas to managing union workers by this presentation. As long as union manager understand the contract, rule, and their workers, it is not going to be that difficult. Please have a confidence to be a union manager, okay? If you have a question, please let us know. Thank you so much for watching our presentation. I hope you guys have a great day.